Stories.
Now, just a few days after the High Court punched holes into the quest for constitutional reforms by barring President Uhuru Kenyatta from assenting to the BBI bill should it be passed by Parliament, the fate of the bill is in limbo after President Uhuru Kenyatta suspended parliamentary activities to curb the spread of the coronavirus disease. In the High Court ruling, the 5-judge bench that has been hearing consolidated petitions against the process issued conservatory orders preventing the president from adopting the bill until all the petitions against the bill are resolved. Following Kenyatta's directive on Friday last week, the Joint Committee on Justice and Legal Affairs that has been discussing the constitutional amendment bill did not meet on Sunday, as was scheduled to finalize its report on the bill, raising concerns over the fate of the bill. Tonight on Pundits Night, we make sense of the president's directive to suspend the House sittings amid a legal tussle with petitioners. Joining us live on our discussion, James Wahome Ndegwa, Speaker of Nyandarua County. He is also the chairman of the County Assembly's Forum. Frederick Okango, the General Secretary of the Third Way Alliance, as well as our resident analyst, Herman Manyora. Good evening, gentlemen. Welcome to Pundits Night here on TV 47.
Good evening. Good evening.
All right, before we begin, be sure to tell us where you're watching the county's television from. 2222047 is our SMS line. Keep tweeting at TV47KE as well as at Musa Sala with an O at the end. The hashtag to use is Pundits Night. Now, gentlemen, the High Court issued the order to stop the president from adopting the bill if it is passed by Parliament, following an application, of course, by Third Way Alliance advocate Mr. Mutuma, who urged the court that to suspend the bill from being assented into law. The petitioner, of course, questioning the process to amend the constitution, terming it a dangerous move. Let me start with you, Bona Secretary General. Why do you say so? Why do you believe so that it is indeed a dangerous move to amend the constitution?
Thank you so much. First of all, I want to be on record. As a party, we are not party to any application in court. The matter E400 that initially the party had filed had been withdrawn. On 15th of February, if you recall, I did a press conference together with my colleagues at Serena, and all the matters that were filed against the BBI were withdrawn. We are out of petition E400, and any person who is purporting to be speaking for the party through court is a persona non grata. And therefore, any application that was filed was not filed in the name of the party, but in the name of individuals who are seeking for relevance and seeking for their stomach. To that extent, we are not party to that. And I would want to say that I don't think there's any problem with the constitutional amendment. Remember, we appeared before the Task Force Committee on 11th March last year, and we did present our views, and our views out of the 15 issues in the Punguza Mizigo, 11 of them today are in the BBI. Among them is the Ward Development Fund, that 5% increment of county allocation, the achievement of that gender, and also the strengthening of IEBC. So to that extent, we are happy as a party that we are likely to see the achievement of the issues that the people, wanted to be achieved through constitutional reforms. So I would say that the issues in courts have been canvassed. The 5-judge bench will be giving a ruling over those matters, but be that as it may, the application that was filed by people calling themselves Third Way Alliance Kenya lawyer, they are not our lawyers because we are the client. They have been our lawyers before, but on this matter they were not. They just relied on the name of the Third Way to file petitions in court. And it is not a new application because they were trying to expand the orders that were given against IBC in February. And if you read that order that they managed to get, it is not barring per se the president from ascending to the bill. It is a middle ground that the court is just trying to understand and trying to interpret and get a middle ground where there's no one who can be given an authority to continue the process. But ultimately, we believe that the matter will be resolved, and Kenyans will finally enjoy their voting in a referendum when that happens. So I want to be on record again, as Third Way Alliance Kenya, we are not in court. The E400 of 2020, the petition, had been withdrawn. And now, what is happening, there are merchants who are using the existence of courts to be a nuisance to the people of Kenya through, frivolous petitions, through applications to delay this process. Those are tactics that we have seen in politics before. There is a lot of politics in court, there's a lot of politics in the political parties, and there's a lot of politics outside here. So we are not in court.
All right, fair enough, Bwana Okongo. You've said that your issues were sort of taken into account in the BBI report, but there are so many Kenyans. Absolutely. Yes, there are so many Kenyans out there whose ideas or opinions or views have not been taken into account in that particular report. But let me cross over to Bwana Speaker, Mr. Ndegwa. Why do you think that it was a bad move, or rather the BBI is a wrong move at this particular time and moment?
I think a constitution is always a dynamic document, and it is made for the people. And there are new things that are emerging every day. And therefore, a constitution cannot be a static instrument. And therefore, this is merely the First Amendment. And therefore, I think that there was need for this amendment, and especially speaking for the county assemblies of this country. We had very critical issues that we wanted addressed in these documents. And all of them were actually addressed by the Haji Committee. The ones that were not addressed by the Haji Committee were addressed in the BOMAS 1 document. And those that were not in the BOMAS 1 document, even after the BOMAS 2 congregation, our issues were addressed. One was that 5% of resource allocation to the counties. And when it is documented in the Constitution, the other issues of implementation will come, and we shall cross that bridge when we reach it. The other issue was the War Development Fund. That is a battle that we have been engaging with or on with both the executive and the two houses of parliament since 2014, because I was still the Speaker of Nyandarua. But we have never made any headway. It is only through this First Amendment that we have gotten an opening now to deal with the issue of the World Development Fund. There is the financial independence. If you go across this country, you'll find members of county assemblies crying because governors sit on our budgets, despite our budgets having been allocated directly by the Commission on Revenue Allocation, being approved by the Houses of Parliament, and being brought to the counties for appropriation by the county assemblies. Governors sit on these monies. But with now the proposed constitutional amendments, county assemblies will have their own county assemblies fund. We shall not have any recourse on the executive to be able to move on. We also asked that ministers in the counties, that is the county executive committee members, they come from also the assembly, at least 50% of them. It is also contained in that document. We had also asked on the empowerment of those who are already in society. And at Article 11A of the First Amendment, that is elaborately and unequivocally taken care of. So again, the chief executive officer at the county government, who is the governor and the deputy governor, they hold that executive power. In the present constitution, there was no requirement at all that they are answerable to who. But now, with this amendment, it is making it very clear that they are the chief and the deputy chief executive, but directly answerable to county assemblies. There was also another discrimination in the present constitution, that to contest for parliament or senate as a member of county assembly, you had to relinquish your position of MCA 6 months before the elections. That one is being removed by this First Amendment. Therefore, there is a lot of shenanigans that are going around this whole regime of amendment of the Constitution. But as the assemblies, and I've said that previously, is that we are happy with the First Amendment because it is carrying all the aspirations of the members of the county assemblies in this country, and by extension, Wajiko at the grassroots.
All right, Bwana Speaker. Let me just cross over to Herman. The two gentlemen here are saying that their views were taken into account, but as I said earlier, there are so many Kenyans whose views were not heard. We assume that they'll be heard through the ballot, of course, in the coming referendum, if at all it will happen. But, Prof, should we be having this conversation? Is the time right for this conversation?
Talking about good things has no time limit. When you have a conversation about good things, you cannot say it is too late or it's too early. So we can talk about our country, and BBI is about our country. That conversation can go on. However, like any other process, there must be termination of sorts. It's come to the end of the process in order to move forward. So after having moved around the country for about 2 years and gone to Bomas twice and open up the discussion and amendments, and having gone how far we have gone now in terms of the bill, in terms of the signatures, in terms of the county assemblies, and now in the parliament, I don't think we can open this with the intention of changing anything. To enrichen it just for future, yes, we can discuss. And that's how the Constitution wanted Parliament to view these things. That when we give you this bill from the county assemblies, discuss for posterity, there's a Hansard report for future engagements, future reviews, but you will not be opening it up. So yes, we can talk, but for as far as opening up this is concerned, I don't think this is the time for that, unless we are talking about another constitutional amendment, not this amendment bill of 2020. I don't think there's room for opening up now. And the argument about Parliament is bringing out is neither here.
All right.
The Constitution under 257 is so clear. Yes.
All right, Herman, let me just interject at that point.
You are saying something?
Yes, let me just interject at that point. The anti-BBI crusaders insist that the BBI does not reflect the will of the people, and in that the public was completely locked out from the amendment of the country's supreme law. The BBI report by the Joint Legal Affairs Committee was presented to Parliament following a 7-day public participation exercise. Now, given the fact that the document cannot be amended at this point going forward, does it mean that public participation was just a way of massaging or rather a constitutional formality? Prof.
Parliament having public participation for the simple reason that this is a public document. This is a public bill. The public have participated in generating their own bill. It has gone to their representatives at the lowest level. Parliament has no role left other than to convey it to the next stage. There can be no public participation because this is already a public and publicly endorsed document. Other than going around to seek the views for the past 2 years or so, there is also the aspect of the signatures, where 4 million or thereabouts, the Constitution talks about 1 million. What the Constitution says, Musa, is this: if 1 million Kenyans can feel there is need to amend the Constitution or to introduce a certain law in this country, that is good enough, because there can be no public participation. Even if you gave them 2, there can be no public participation. Bring 1 million people on board to engage. So I also personally don't believe in public participation, because if they go to my home county of Vihiga, I have watched what goes on. The same people from Nairobi here follow those people to be eager to go and engage in public participation. But that is beside the point. The point is, this is a public document produced by the public, gone through a public process, endorsed by over 1 million signatures. And therefore, to say you can now open it up for public participation, what public participation could you be talking about? It was not necessary.
Fair enough.
Neither was it even practical.
Fair enough, Prof. Fair enough.
Sir.
Yes.
I think I agree with Prof.
Mm-hmm.
I agree with Prof. Haman. The reason why the bill is going through what we call a popular initiative, as envisaged in Article 257, is because it is a popular bill with the people. The reason why the bill has undergone extensive public participation is because this type of bill is a proposition from the public. The first instance of public participation in the BBI bill, or any popular initiative for that matter, started when Kenyans presented their views from the 47 counties and gave their views to the steering committee and to the task force. Then the second level of public participation arose when over 3 million Kenyans endorsed the bill. Then the third level of public participation occurred at the county assemblies, where the constitution requires that such a bill must be decided on and voted and passed by majority of the 47 counties. In this instance, it was overwhelmingly passed by over 43 county assemblies. Then the fourth level of public participation is at the National Assembly. Constitution under Article 118 demands of the members of National Assembly to facilitate public participation. And in this instance, I have seen people argue that they are having a ceremonial role. No, it is by that virtue of the Constitution as provided for in Article 118 that they shall now look into the bill and update the public on the content of the bill. The public interact with the bill and also ask questions and guidance. Remember, the National Assembly are the only lawmakers. The Senate are participants of lawmaking. The county assemblies are also having a legislative authority. But here is a case where we have seen arguments from a section of the National Assembly and Senate. They must desist from the excitement to want to open the bill, because that bill, they cannot open it. The bill, and the Speaker will tell you, that bill is not an ordinary bill. It is not a money bill. It is a special bill. A special bill in the sense that it is a bill that is emanating from outside. And from outside means here public. Therefore, it will be very dangerous to open that bill. Having been endorsed by over 1 million threshold requirement in Article 257, if you open it, then you shall be rendering the process of popular initiative moot. In fact, it is dangerous and people might even go to court. I want to urge members of National Assembly, they should take cue from the county assembly members who considered the bill on its merit and passed it overwhelmingly. Today, the National Assembly and Senate, the bicameral house, has only two options, Musa. Option number one, pass the bill on its merit as is, and then the bill proceed to the president for assent. Then the president, having considered and being advised that the bill contain matters that relate to Article 255, then the bill shall go to the referendum. Secondly, reject the bill as is, and still the final public participation, which is the fifth one in a popular initiative, shall take place in a referendum. Now, the issue here is the section of members of parliament that now is when they have realized that they need to look at the bill because they think that they have a say more than the people that endorse this bill is misplaced. It has never happened. It shall not happen. It will not happen. And that's why I submit that there is no BBI in a limbo. The process started. It is continuing. The only break that will be put on the bill is at the final referendum, when Kenyans will wake up in the morning to go and make a decision on the bill, because that bill has got several aspects that require the public to participate in the last final public participation. Number one, look at the Bill of Rights. Any matter that relates into the Bill of Rights, for example, BBI has now incorporated the new aspect of Bill of Rights by looking at privacy. Number two, any matter that touches on function of Parliament. Today, look at the functions of the Senate, which is part of Parliament, that now shall oversight money, not only that from the national government, but even the grants and any other money. Any issue that touches on the structure of devolution must go to the people. The BBI has proposed
let me cut you there. Let me interrupt SG there. We have to take a short commercial break, but we'll get deeper into matters, the Constitution and of course the BBI bill in a moment.
Thank you.
You are watching TV47, the home of untold stories.
Umepata habari hizi njema kutoka kwa Morogo Herbal Clinic. Due to public demand, sasa tumepunguza bei ya dawa yetu maalum ya kuimarisha nguvu za kiume ya Libi Power kwa 50%. Katika ofa hii ya mwezi huu, full dose ya Libi Power sasa utaipata kwa shilingi 11,200 pekee. Half dose ni shilingi 8,700, nayo sachet ambayo itakuhudumia vyema kwa hadi kipindi cha miezi 6 ni shilingi 2,500 pekee. Ukilipa kupitia nambari yetu ya Paybill 500888, tunakutumia dawa hii popote ulipo kote nchini na hatutakutoza malipo ya usafiri. Kwa maelezo zaidi, wasiliana nasi kupitia nambari ya simu 0722997788 au 0705191919. Harakisha ujipatie Libi Power yako hii leo kabla ya ofa hii kukamilika. Libi Power, imarisha penzi lako.
Mimi sipendi unapanguza floor. Hiyo dust uache hapa kwa meza. Clean up. This is a problem, eh? Next time, uende ununue selector yako, utengeneze sandwich zako, uachane na sandwich za boss.
Selector. The difference is in the taste.
Finca Properties Limited introducing Equator Gardens Phase 2 Nanyuki, a few minutes drive from Nanyuki town near Olpajeta Conservancy. This is a strategic property offering a homely serene environment with nearby schools, hospitals, with a space for children playground and kindergarten. Invest today with a cash offer price of 200,000 for 50 by 100 plot and a discounted price of 350,000 for 100 by 100 plot of land. Legal fees and transfer costs inclusive. This is a gated control development property with water and electricity on site. We offer free site visit every Wednesday and Saturday. Visit our offices in Kitengela Pena Towers first floor. Contact us on 0721 737300 or SMS the word plot to 40309. Title deeds are ready. Finca Properties Limited, prime and affordable.
You are watching TV47, the home of untold stories.
Welcome back. You're watching Pundits Night here on TV47. Before we went for break, and still joining us is James Wahome Ndegwa, Speaker of Nyandarua County. He's also the chairperson of the County Assembly's Forum, Frederick Okango. I hope I said that right. Bwana SG is the Secretary General of Third Way Alliance, as well as our resident analyst, Herman Manyora. Before we went for break, we were talking matters, public participation in the BBI process, and just to take a little detour of our earlier argument, the BBI petitioners, you said they are not aligned to Third Way Alliance. They are specifically serving personal interest, but rather they also question the manner in which the BBI bill was presented to the county assemblies. And it's good that we have Speaker Ndegwa with us tonight, saying that it was hurriedly done in a choreographed script to lock out Kenyans, especially those with dissenting voices. Now, let me start with Bwana Ndegwa, Speaker. Looking back at how senior pro-BBI politicians, including President Uhuru Kenyatta and ODM leader Raila Odinga, campaigned for the report, at the county and national levels. Would you say the process was hurriedly done?
I think this process has taken a total of about 2 years. I don't think that a process that has taken 2 years can be said to be hurried. The other issue I would want to address here is the way Parliament is approaching the amendment bill, the Constitutional Amendment Bill 2020. I believe, one, as a lawyer, and also having also looked at the Constitution, that the Parliament has no role in a proposed amendment under Article 257 of the Constitution. And the simple thing is this, that this is a document that has been taken to them on the strength of support by the people. People signed to a document that they had been taken through. Anything that might be added by the members of Parliament cannot have the support of those signatures. So an amendment with the support of the signatures would be null and void. And I don't know why Parliament cannot see these very basic things. The second issue is that whether Parliament reject or approve this document, the document in the same form and style will still go to the members of public for referendum. So for me, and as a lawyer, is that even if they want to introduce any amendment, the document that will go to the people is the document that has support of the 4 million signatures. Any amendment they would want to introduce there, that amendment would not go to the people. Just the same way, they would reject the whole document, but the same document would still go to the people to make the final determination as the holders of sovereign power, sovereign will of this country. And therefore, even public participation, I would agree with Prof. Manyora that most of this public participation, they are just mechanical. They are learned through so that they can satisfy some requirement of the Constitution and the statute. But at the end of the day, they don't go to achieve the intended objectives of the Constitution and the statute. And therefore, public participation, however, like the way we did it in Nyandarua, and I told the people of Nyandarua, we are coming to you, not that we are going to amend this Constitutional Amendment Bill 2020. We are going to put across your sentiments, your participation to the members of Parliament so that they can be considered in the statutes that will facilitate the implementation of the Constitution. So the public participation is not in vain, because we have 12 pieces of legislation that will facilitate the implementation of this Constitution. And therefore, members of Parliament can, in passing or enacting the facilitative legislation, be able to insert or incorporate their own wisdom and the aspirations of this country. But touching this document is very dangerous, and Parliament is taking us back. Finally, I have seen even senior counsel, a person I respect, in James Orengo, saying that to say that no amendment can be introduced is childish. Actually, that one took me aback, and I was actually shocked, because Orengo trying to equate what happened in 2010 and what happens now is completely does not hold any rationale at all. In 2020, we were doing a new document, and all of us talked into that document, spoke to the document until it was enacted. This is a first amendment to a constitution that is already there. Parliament is not welcome to make any input on this particular document. Whether they are made, whether they are reject, whether they approve, the document will go the way it is to the people for their voice.
All right, Speaker, fair enough. Before we move over to Herman Manyora, I'd like just to read this. It is from the Constitution that a bill to amend the Constitution shall not be called for second reading in either houses within 90 days after the first reading of the bill in that particular house. This means that at least the least time Parliament can take is 90 days, assuming all the other processes are crammed into one day after the immovable deadline between the first and second readings. It also does not, the Constitution does not state the period for introduction of a draft bill in Parliament upon approval by county assemblies. Now, with the new directive to curb the COVID-19 and the suspension of Parliament sittings, the BBI timelines have gotten murkier. Now, how does this presidential directive change the BBI timeline altogether?
Maybe just a small interjection.
Mm-hmm.
The 90 days window is only created for a bill that emanates from either House of Parliament, because it is not a popular initiative. Therefore, to read it from the first reading to the second, it has to take 90 days. But a popular initiative has no timelines. Mm-hmm. It can be run through Parliament even within 14 days.
Musa, just to add before you go to Prof, just to add on what Senior Ndegwa said, you see, the bill we are dealing with currently is a bill that is not, the origin of the bill is from the public. That bill is not from Parliament. That bill is not ordinary bill. That bill is not money bill. And you cannot treat it as the money bill or ordinary bill. This is a bill that has come from outside. And the guidelines to treat this bill are enumerated in Article 257. Number one, when that bill comes from the county assembly, it shall be introduced in Parliament without delay. Number two, the Parliament shall only pass that bill through a simple majority. And that can happen anytime after they have debated it. So when you take such a bill through a public participation and expect that you shall incorporate the views of the public, the principle of public participation is that the final decision making must incorporate the view of the public. But in this bill, as I explained earlier, it has undergone extensive public participation processes, even without Public Participation Act. So the only last public participation that this bill requires is public participation in the form of a referendum. So what you are reading is guiding the ordinary bills and the money bills, not the popular initiative bill. Number three, the argument that have been pushed in Parliament have been contentious. You have talked about Senior James Orengo. If you listen to Orengo, he is not speaking into the law, he is speaking into the politics. And the politics is that the issue is about the 70 constituencies. I hope we have time and discuss it. Those 70 constituencies are an issue to majority of politicians, but they are forgetting that when they were proposed, they are proposing to implement a constitutional principle in Article 81 that requires that the representation must be fair and based on equality of vote. And therefore, when people argue that IBC's role is being usurped, it is wrong. When you read the limitation of electoral units in Article 89 sub-article 2, it says that the commission shall be involved in the limitation of the boundaries and the names of the constituencies. And when you go to sub-article 3, it says the commission shall be involved in the limitation of the names, number, and boundary of the wards. In the BBI, what has been proposed is the number of constituencies. To that extent, there is no usurping of any role of IBC. In fact, the consequential provisions of this bill reads that after 6 months upon enactment, IBC shall now go into proper delimitation and now place the boundaries of the proposed 70. So, in my view, again, the argument that is being advanced by a section of Member of Parliament is political. They are trying to play poker card. They are trying to play poker card with Kenyans. They are forgetting that they cannot take Kenyans and ransom. And I agree with the Speaker. Members of Parliament are strangers in as far as amendment of population is concerned. They are a conveyor belt. They must accept it, and they must allow Kenyans to make the final decision in a referendum.
Fair enough, SG, fair enough. Let's move over to now Herman, give him that chance he needed the most. Herman, the two gentlemen have been swayed by the politics of how the origin of the bill rather, but let me just put it clear to you. Does this new directive to sort of curb the spread of the coronavirus disease within Parliament and suspend the parliamentary sittings, are we likely to have a referendum before August this year?
You see, the referendum is both a political and a legal process. The legal process has timelines, but we've gotten to a point where the timelines are no longer in application. They were there when the county assemblies were to do certain things within 90 days or thereabouts. Now it's like a suspended timeline. So that's the legal timeline. But then there is the politics. If the owners of BBI, it has owners, let's not beat about the bush. If the President of the Republic of Kenya, who is the main stakeholder in BBI, and his elder brother, Raila Amolo Odinga, want the referendum to happen before June, it will happen before June. There is corona and certain activities have been suspended. But you and I live in this country, and we know that today, IEBC is receiving papers from candidates who are going to run for the Garissa senatorial by-election. That is a political process. It is going to happen as scheduled. So the BBI that is coming in June, we don't know how bad this coronavirus will be. I was even in one of my YouTube videos suggesting we might even suspend the 2022 election. You can't know how bad this thing can get. But within the context of what is going on, the only person who will determine, unless the situation on the ground, pandemic-wise, is so bad, unless it gets to a point where everybody can see nothing is possible, the power to hold or not to hold the referendum is in the hands of Uhuru Muigai Kenyatta and Raila Amolo Odinga, assuming they are reading from the same script and they want to have the referendum. Nothing can stop that referendum. Parliament, we saw Senate. I don't remember the National Assembly, but I remember the Senate having virtual sittings. I have seen the Senate having meetings across the country. I've seen Senates using more than one chamber. There were some senators within the main chamber, others were outside. So arrangements are possible for the purposes of passing this bill. And like my colleagues have already said, I think my friend Fred, this bill is not an ordinary bill. It is not limited. They are not restrained in terms of the procedures and the timing that, like you are reading about 90 days. They can do this thing in a week's time and it's gone. After all, they are all, much as they are trying to argue, and they are bringing politics, much as they are trying to argue, their role is so simple because they are the only institution in this country that we have given the mandate of lawmaking. So whether the law is from popular initiative or not, Parliament must touch on it and give their blessings. In this case, they are blessings in the form of passing that bill or not passing it. But they are conveyor belt. Just like, for example, the president makes certain appointments in a more or less a ceremonial way. He tried to argue about the Chief Justice. He was told, no, the law is clear. We will give you a name, not three, one. And that name, you have to take it to Parliament. That's your role. Then Parliament approves and you just appoint the person. So Parliament is in more or less the same way, like where the president finds himself having only a ceremonial role. So it can take place, yeah.
All right. Let me bring in. All right.
On that one.
Mm-hmm. Speaker, before you comment on that, I'll just like to take you back that this is not the first time Parliament has been suspended in the quest for a constitutional reform. When the late former President Moi was faced with an election that he would not participate in directly, but he would rather participate in through his handpicked successor at the time, President Uhuru Kenyatta. Moi had already started planning his successor, of course, and a new constitution did not feature in his plans because of his unpicked successor. And Uhuru Kenyatta went into the elections under the old constitution. Now, to deflect the then rather civil society, the National Convention Executive Committee's pressure and refusing to cave into the demands for a new constitution, President Moi, of course, suspended Parliament on October 25th, 2002. Now, bearing in mind that President Uhuru Kenyatta was the political student of the late former President Moi, could President Kenyatta be repeating the same thing his teacher did?
Okay, Musa, I don't agree that I don't believe that that can happen in the present realities in this country. That time, the president was in charge of the calendar of Parliament. He would decide when Parliament goes home, when it reconvenes, and how it does its work. The calendar for today's Parliament is actually dictated by the Constitution itself. And the reason why the two speakers of Parliament have convened sittings tomorrow, so that in following with the President's request, they can be able to adjust their timetable. And we are expecting that everything that is in this constitutional amendment bill, and taking cognizance that Parliament does not have any inbuilt participation in the constitutional amendment bill that require them to sit and interact so heavily as they are purporting to do, even bringing in experts to advise them on how to go about this very plain issue. That obviously don't know what they would expect the experts to tell them. I expect that the president was very genuine and honest, and from reality, I've said, I was talking with the Secretary General, telling him that I'm knowing of a person known to me directly, every day, dying from COVID-19, and others admitted all over the hospitals in Nyandarua and Laikipia. And therefore, the president talked from reality of what is happening today. The other issue is that even if Parliament is suspended, I believe tomorrow when they meet, they will agree to deal with these issues factually. And mainly for the reasons that the court never stopped Parliament from transacting on the Constitutional Amendment Bill 2020. So Parliament should be able to deal with this bill conclusively within the shortest time possible. And thereafter, I expect that all the issues that are before the court has already been able to identify what were the issues. And if they are able to decide the constitutional presidential petition within 14 days, is that our court can also be able to determine all the issues before them, even within a month. And us being in the month of March, that has given them a whole month of April. Then, therefore, we should be able to proceed and have our people have their say on where they want this country to go and what kind of legislation or constitution they want it to guide them. And the SG mentioned something about the IBC. I agree IBC has overwhelming powers on boundary delimitation and naming and numbering and everything. But when the people speak, and Article 1 of the Constitution, everybody takes a back seat. So if the people speak in the referendum about the 47 constituencies, the IBC can only follow what the people say. Those are about powers they are talking about. It is donated to them by the people. If the people speak, everybody takes a back seat and implement what the people of this country aspire and want.
All right, Speaker, let me bring in SG. SG, Bona Speaker said that President Moi's time and Uhuru Kenyatta's time could not be the same, considering the fact that Moi was acting under the old constitution that gave him powers over Parliament. Of course, he could call Parliament and, of course, suspend it at his own pleasure. But what are your thoughts? Could President Uhuru Kenyatta be repeating the same thing?
Thank you, Musa. First of all, I agree with what my colleagues have said. Number one, during Moi's time, those are the times when the president would exercise imperial powers, and those powers were interfering with institutions. The reason why we came with the Constitution of Kenya 2010 is so that we can check the excesses of institutions that were powerful. One of them was presidency. The other ones were, the commissions and the rest. But at this time, there is only one instance when we can extend the term of parliament. And that time can only be done when Kenya is at war. The interpretation that maybe lawyers would be seeking to get is when you go through Article 1 or 2, to what extent can we push the envelope, if at all that is what some people want, so that we treat COVID-19 as a biological war. And then we can now argue and seek interpretation in court that maybe at that time, then term limit of parliament can be extended. And the Constitution also says that it can only be extended by 6 months and only twice. So that's maximum a year. I don't see much happening within a year, because I have heard people argue that the economy is doing badly. That is true. I have heard people argue that we are not ready for election. That is not true. The commission is properly constituted. The Constitution of Kenya says that there shall be at least 3 commissioners and a maximum of 9. Currently, they are 3. So they can conduct an election just like they have done in by-elections. Number 2, this bill that we're now talking about, it will be disastrous to postpone the referendum to another year or by another several months. Why? The cost of postponing the inequality in this country is just too heavy. The cost of postponing money that is going to the pockets of the majority in the county is just too heavy. The cost of postponing electoral violence after every 5 years is just too heavy. The cost of postponing the injustices meted against women, the inequality, the gender inequality is just too much. We agree that while Kenya is undergoing a lot of issues, but the solutions also lie in the document, because we are looking for a long-lasting solution, not quick fix. The quick fix the president and his government have given us away by cushioning, the country. And now what we are looking at is how do we secure the lives of Kenya for the future? So I don't see a situation where President Kenyatta would want to make a mistake, because he understands that the only legacy that now he can leave Kenyans with, given that his time is running out, is a Kenya that has got an equitable economic system that recognizes livelihoods like agriculture, pastoralism, blue economy, digital economy. That is what the BBI is talking about. The president recognizes that it is time for women to get into leadership. They are suitable, capable, and competent. That is what BBI is talking about. The president recognizes that even in dealing with institutions, we must strengthen our institutions like ODPP and make them part of the independent commission in chapter 15. That is what BBI is talking about. I want to see a situation where Kenyans read the mind of the president, because when you argue that the president might want to pull a Moi on us, no, the president recognizes that it is time barred, and we, the people of Kenya, as the speaker said in Article 1, we have delegated power to these institutions and these members of parliament. That power they must exercise at our behest, and they cannot do anything with it without our say. We, the people, we have spoken. We have said through our proposal that we want a country that is equal. We want a country where everyone gets equitable opportunity in business, in education, in healthcare, and in every aspect of life. That opportunity has presented itself through a constitutional amendment. The other thing is, look at the political interest. Today we are talking about alliances. Where is this alliance leading us? We want to question the politicians, me included, that when we are dealing with matters constitutional amendment, we must put aside matters 2022, because we have mixed issues. The moment we start looking at succession and start imagining that with BBI we can now succeed President Kenyatta and sit on the seat and implement, then we lose it, because there are people who are pro BBI, but they are not pro certain candidates. There are people who are pro certain candidates, but not pro BBI. We must put issues aside. But today, I can assure you, Musa, what Kenyans want to see, the moment tomorrow, and I can predict, the moment the speakers meet tomorrow in a special sitting, they will be looking at business that is urgent. one of the most urgent business today is to ensure that they get hold of that bill, the committee report, and give direction. I see a situation whereby the first week of April, the committee might table the report virtually and they might vote on it, and then the bill will go to the president. The constitution also says a referendum can now be organized through IBC within 90 days. Within here means even 5 days after being assented to, it can happen. So it is in the interest of majority that we put things aside and deal with the most urgent. Most urgent as we fix the economy is also most urgent as we look at the long-lasting solution of our historical problems.
All right, SG, you've talked about matters, coalitions. I'll be coming to that in a moment, but Professor Haman, constitutional amendments have preceded every Kenyan election since 1992, and you'd agree with me that the question is, have these amendments brought about real change, or are they merely tools that are used to entrench the status quo?
Well, I would have loved to see a constitution that puts the common man, Wanjiko as we call them, at the center of things in this country. Unfortunately, most changes have been about the big barons, the power brokers, the politicians. So yes, we have been looking for this constitution for a while. We have shed blood, people have died, people have gone to jail because of the changes we aspire to have through our constitution. And yes, we have had one in 2020. We are about to have another one. I suspect it must be this year, because if the BBI means so much to Uhuru and Raila, if they don't have it latest July, August, then they can't have it again. Because you can't have it just before you have the 2022 January. Certain things will not be possible. So technically speaking, they can have this before August latest. So yes, we are about to have another one. But to be brutally honest, I don't think the changes are really for the benefit of the common person. And it's not surprising. Governance and modern statehood really is about the governors, not the governed. The modern state is an arrangement to make a few people enjoy the resources of a country. And they may use all sorts of words trying to lie to us. They are competing, or they are trying to be nice to us. Never. The governance is not really about the common people. It doesn't work like that. That's why, these are politicians there.
All right,
I haven't joined them, so I can speak from this other side.
Yes, Prof. I'm told we have... Prof.
Let me just finish, please. Half a second.
Mm-hmm.
Yes?
All right, Prof.
What I'm saying is, that is why, if you look at... Can I go ahead?
Prof, we have to take this short commercial break.
Can I go ahead?
Just a minute, we'll be back. We have to take this, Prof.
Okay, fine.
Right. We'll be back in a moment.
Okay. Okay, fine.
You are watching TV 47, the home of Untold Stories.
Umepata habari hizi njema kutoka kwa Morogo Herbal Clinic. Due to public demand, sasa tumepunguza bei ya dawa yetu maalum ya kuimarisha nguvu za kiume ya Libi Power kwa 50%. Katika ofa hii ya mwezi huu, full dose ya Libi Power sasa utaipata kwa shilingi 11,200 pekee. Half dose ni shilingi 8,700, nayo sachet ambayo itakuhudumia vyema kwa hadi kipindi cha miezi 6 ni shilingi 2,500 pekee. Ukilipa kupitia nambari yetu ya Paybill 500888, tunakutumia dawa hii popote ulipo kote nchini na hatutakutoza malipo ya usafiri. Kwa maelezo zaidi, wasiliana nasi kupitia nambari ya simu 0722997788 au 0705191919. Harakisha ujipatie Libi Power yako hii leo kabla ya ofa hii kukamilika. Libi Power, imarisha penzi lako.
You are watching TV 47, the home of Untold Stories.
Welcome back. You're watching Pundits Night here on TV47. Tonight we are talking matters the BBI and whether the BBI or reggae has been stopped by COVID-19. Just before we went for break, Third Way Alliance Secretary General had talked about alliances. But before we get into that, Herman Manyora, our resident analyst, had talked about that this process does not stand to benefit the common mwananchi. And I have one person here who's watching us live on Facebook. Kirua Pat says BBI should be killed as soon as possible. Nothing will be achieved out of it. It only stands to benefit politicians. Speaker, what do you make of this? Is this true? Speaker Ndegwa?
Yes, I'm sorry. I'm sorry about that one. That I think that cannot be correct. And Kirwa is actually what he is saying is really a shot in the darkness. And I think he's just being adventurous. Because most people who talk negative things about the BBI is the people who have not read it. When we are talking about that 5% of all revenue in this country coming to the counties, that is the biggest transformative agenda that a country can ever have. Because the best countries in devolving funds in this world, they go up to 40, 45. And nothing is that. I don't think any other country, any other democracy in Africa, and in the middle level countries has ever gone anywhere near there. The other issue is that when we talk about World Development Fund, although Professor is talking about that politicians working for themselves, we have seen what CDF has done at the constituency level. And now it is agreed that more money come at the world level, where people directly have a say in how they are governed, and how the development in the areas is planned. We have talked about the governors, and we agree that really corruption has been devolved into the counties. We are saying now that these governors will be answerable directly to somebody, so that there is prudent use of resources. We are talking about Article 11A, about the common mwananchi. That is a very progressive article in the Constitution. I have not even seen it in the South African Constitution, which is doing very well. And therefore, I said this is a very good constitution for mwananchi in this country. What we just need is that we deal with the Constitution now. We have the referendum, we pass the First Amendment, and then we sit down as a country and agree how do we implement this very beautiful piece of our Constitution.
All right, Speaker, I'm told we are running out of time, but as we conclude, we talked matters coalitions. There have been rumors that Deputy President William Ruto, of course, has been sidelined from the beginning of this BBI process, but now there are rumors that ODM leader Raila Odinga could also be sidelined towards the 2022 presidential elections, and that we may be seeing a coalition between Deputy President William Ruto and ODM leader Raila Odinga. Prof, what do you make of this?
I think you are getting where I was in my YouTube video this Saturday. There are two things here. We have 2022 and we have BBI. I think there are people, especially in ODM, who are trying to force 2022 into BBI. So when they see President Uhuru Kenyatta doing certain things in order to ensure that BBI goes through, because at the end of the day, you may not quite tell whether Ruto may not spring them a surprise towards the end and oppose the referendum. So what the president is doing is building firewalls in every region. And that he may be seen, therefore, to be supporting Mudavadi Wetangula. And he go to the coast and he thinks the division there may give Ruto an entry and deal a blow to BBI. So while the president is busy dealing with BBI and doing certain things, the people in ODM, some people in ODM are seeing those things and interpreting them to mean he's perhaps offering support for Gideon or for Mudavadi at the expense of Raila. I choose not to see it that way. I choose to see this as mere confusion on the part of ODM. And they're the ones who are breeding all this. And there have been rumors that even the BBI secretariat has been disbanded. I have it on the authority of the people in charge that there's nothing like that. So I don't think we can talk about a Ruto-Raila alliance arising out of Raila being sidelined by Uhuru. And finally, much as I have said that if Ruto and Raila were to team up, the kind of energy they would generate, there would be nobody in this country who can beat them. But having said that, I must quickly add, I see that as a most unlikely thing. In politics, anything is possible. There are no permanent enemies. We have been told that many times. But this one, between Raila and Ruto, it will be very difficult for me to look at Raila in the eye as he convinces me that he's teaming up with Ruto. It will be very difficult. So I don't see it happening. And more so, I'm not convinced the reasons being given are true.
All right, Prof. As I said earlier, we're running out of time. We have less than 1 minute. I'll give each of you at least 30 seconds to give your remarks. Let's begin with Bwana SG.
Musa, thank you so much. In politics, everything is possible and anything is possible. And when there's a rumor, then that rumor can be actualized. However, it will be very dangerous for Raila Odinga to work with William Ruto, because it will be making Ruto the president, not Raila the president, because Ruto has served his second term as a deputy president under the current constitution, and he can only be president. Number two, people have said that the president is endorsing certain quotas. No. The president is trying to create a wall to secure BBI. The president is convinced, and I can speak with authority on this because I have interacted with people that belong to the president, I have interacted with people that belong to Raila Odinga, and what they have told me is that the BBI is a priority and 2022 is not a priority. And Raila Odinga knows that. We cannot go into an election without implementing the new, without passing the new constitution. We are waiting to see, and the Kenyans would want a situation where they vote for a new referendum and go for an election with a new referendum or with a new law that gives equal opportunity for all of us.
All right, less than 10 seconds, Bwana Speaker. Your last closing remarks on this part.
I would want to say that in politics, everything is possible.
Right.
And I would not be surprised if the Prime Minister works with the Deputy President. They have worked together previously, and therefore it would not be anything new. But further is to say that constitution making is both a legal and a political process. But I'm appealing to especially our members of parliament, let us put our country and our people first.
All right.
And also to alert them that this constitution we are making is not only for the present, it is for the future and for posterity.
All right. Well said, Bwana James Wahome Ndegwa, Speaker of Nyandarua County. He's also the chairman of the... All right, Prof, I'm told I've not been fair to you. Less than 2 seconds, Prof. Go ahead, Prof.
Say this, I was going to get very annoyed. BBI is at the foundation of handshake. And Raila is part of that handshake. Uhuru cannot betray the handshake, just as he cannot betray Raila. For Uhuru to betray Raila in the manner some people are suggesting today is to tell us that Uhuru will want to return Kenya to where we were before 9th of March 2018 when the handshake happened. And that what they told us, they have seen the problems of this country. It was not true, they didn't see. So it's most unlikely the shenanigans and rumors going around about betrayal. These two gentlemen are focused. Let's listen to them. They intend to change this country, and I think they will.
All right, all right. Herman Manyora, our resident analyst, they are saying we are due to expect more political, of course, surprises in the political arena in the coming days. We also had the Third Way Alliance Secretary General, as well as the Speaker of Nyandarua County, James Wahome Ndegwa. Gentlemen, many thanks for making time for us here on Pundits Night on TV47. It's always a pleasure having you on board, but it's here that we say good night to our viewers. Many thanks for making time for us here on TV47. My name is Musa Salah. Do enjoy the rest.